If you have any questions, you can directly message the host, which would be myself. But for the most part, I think it should be smooth sailing. You're more than welcome to keep your camera on. Just keep yourself muted. Thank you.
Okay, great. Thank you. So we are on the record in the matter of Michael L. Chase and the Township of Irvington. Counsel, please put your appearances on the record.
Yes, good afternoon, Your Honor. Joseph Donahue, Brickfield and Donahue on behalf of Michael Chase. We're both appearing via the Zoom platform.
Okay, thank you.
Yes, Susan E. Volkert, appearing for the Township of Irvington for the Dakotas firm.
Thank you.
And Greg Hazley, Your Honor, from the same firm, appearing for the township.
Okay, very good. And counsel, I've already introduced you to Jean-Pierre, who is the associate with Riker, who's working with me on this matter. This is a motion brought by Plaintiff Chase to dismiss all disciplinary charges as brought by the Township of Irvington. Now, counsel, I know you have prepared statements, and I'm prepared to hear everything that you intend to say. But let me preface by giving you some questions that I have. Some are directed to plaintiff, some are directed to defendant, and then there's one question that's directed to both counsel. So if you just note what the questions are, and you can incorporate them in your comments, okay? The first question is directed to plaintiff. How does the instant motion differ from those that were previously filed, focusing on the principles of estoppel and res judicata? And I said that's directed to the plaintiff. That's directed to Chase. Okay, Mr. Donahue. The next question is, how would you reconcile your arguments, and then again, Mr. Donahue, with the findings and conclusions of Judge Buechler? And again, for Mr. Donahue, were there any statements of reasons that were issued with respect to any of the prior dismissals? And for Ms. Volkert, how would you distinguish the case at bar from the Camden versus CWA case? And for both of you, is there a reason that you did not memorialize any of the prior dismissals? Okay, Mr. Donahue.
Give me one moment, Judge. I was taking notes on your questions, and I'm going to print them out.
Okay.
Which is going to take me about 10 seconds.
Okay, no problem.
Okay. Thank you, Your Honor. And I'm going to be brief here, mainly because the issues that we're advancing have been pretty extensively briefed.
Yeah, and since we're on the record, Joe, because I'm sorry for interrupting you again. Since we're on the record, I want the record to reflect that I received and have read all of your submissions, and some of them have been, as you say, quite extensive. Go ahead, I'm sorry.
So we submitted both a moving brief and a reply brief addressing many of the issues, or at least some of the issues that you've raised in your subsequent questions. But I'm going to just highlight our arguments. But as I said, these were extensively briefed by defendant, and we submitted a 33-page motion to dismiss, and I think it was a probably a 15-page reply brief as well. So
Right.
in any event, Your Honor, so basically what I've been trying to nail down from day one, since you've been on this matter, is what dockets or is the township pursuing? And this was I'm better at being obnoxious than most lawyers. So I kept raising this issue because it concerned me and my client from day one. And what continually happened is these charges grew and grew and grew and grew in number and amendments, and it just became extraordinarily confusing. That's why I tried to nail it down, and I repeatedly asked for clarification on this issue, both on the record before Your Honor and in written form. So as I understand it, what we have now left is 212-226, 212-227, 212-227A, 212-286, and 212-290A. Of all the universe of charges, 290A is the granddaddy of all of them. It's got 130 plus charges. The balance of these of the charges in these other four dockets are significantly less in number than 290A. And 290A, just so the record's clear, is the internal affairs charges. So 226 and 27 and 27A all amount to disobedience to orders. 286 involves the Sampson IA. And I think Mr. Sampson or Officer Sampson, I think he's a sergeant now. Sergeant Sampson is actually watching today. In any event, those are the charges as I understand them. The very strange thing that has happened in this case, highly unusual in my experience, and I would submit highly unusual in the experience of everybody on this Zoom today, and is that my client is now 71 years old. He served as an officer, a police officer, in virtually every position within Irvington Police Department for 40 years, roughly 40 plus years. It's highly unusual that someone with his stature would be facing these kinds of charges, number one, but still facing them after at the age of 71, still facing them after he was terminated by the township in January of 2016, still facing them after he's reached mandatory retirement age in July of 2016. So the fact that the charges are 11 plus years old, the fact that my client was terminated 7 years ago and reached mandatory retirement age almost exactly 7 years ago is highly unusual. But this has been these issues have been argued before you, Your Honor, before, not as in as much detail as we're doing today, but
Right.
certainly they're in my moving paper. So this is a very unusual situation. What's also unusual is that 4 of these dockets, 212, 226, 27, 27A, and 286, were dismissed without prejudice by the township in 2022. We got this notice one day, they're dismissed without prejudice, and just very unusually. Actually, give me one moment here. Actually, it was on April 15th, 2016. I stand corrected, when these 26, 27, and 286 were dismissed without prejudice. That was by Public Safety Director Tracy Bowers. Then what happened is these charges were reinstated in 2022 after the appellate division had finally ruled in this case. So this is a highly unusual fact pattern. So what we've argued in our motion to dismiss is that 4 of these dockets should be dismissed pretty simply and pretty easily by this court because they were dismissed by the township, and they were brought long after my client had already left the department. He was basically shown the door by the department, and he was also mandatorily required to retire by state statute. So because of this, and we've cited the case law relevant to this, we believe that it's a no-brainer as to 226, 227, and 227, 226, 27, 27A, and 286 should be dismissed by you. Another very strange thing that has happened here is that 3 of these dockets, 26, 27, and 27A, were never investigated by the AG's office or by the prosecutor's office, which must be done pursuant to AG guidelines. And I've cited the relevant guideline as 5.1.18 of the Internal Affairs Manual, which is part of the AG guidelines. So this is a highly unusual situation, never investigated. It is required that investigations be done, and they were never done. Also highly unusual. My client also was never given a target letter and never told that he was being investigated or that he was investigated relevant to these 3 docket numbers. And the AG guidelines, IA manual, section 5.1.14 require it. Township never did it. So I would submit to you respectfully, Your Honor, that those 3 dockets just should be summarily dismissed. 286, we've also argued that should be dismissed. 290A, we've made our arguments in our papers. I'm going to rest on those arguments, the rest of my papers, as to 290A. Now,
Counsel, let me just make sure my notes are correct. So with respect to the IAM 5.1.18 and 5.1.14, you're relying on that as it relates to 26, 27, and 27A. Is that correct?
correct.
Okay, thank you.
But yeah, those two sections of the
Right.
AG guidelines, yes, we are.
Right.
And
Okay.
and when I say AG guidelines, that includes obviously the IA manual. That's part of the
Correct.
AG guidelines
Right.
from our perspective.
Got it.
So yes, that's as to those dockets, Your Honor. So
Okay.
you would ask some very specific questions, most of which focused on Judge Buechler. And as the court is aware, we filed an action quite some time ago to dismiss based upon a lot of the theories, not the ones I've just raised regarding the AG guidelines, but a lot of the theories that we've advanced here. And we filed this action before Judge Buechler in Essex County. He made specific rulings and dismissed our complaint. But you had asked specifically today, Your Honor, about res judicata and estoppel. And if you look at Judge Buechler's decision, it's very clear, and we outline this in our papers. He basically said, I'm dismissing without prejudice. But what he's saying is, you have not exhausted your administrative remedies. That's why I'm doing that. And that's why we are here. This is an administrative remedy before Your Honor. That's why this is the first step in that administrative process. And we are following the direction of Judge Buechler. And that's why we're filing this here. And we're not going elsewhere. So I think that answers question number 1, how does the instant motion differ from those previously filed focusing on res judicata and estoppel? And the second question you've raised, how would you reconcile arguments with the findings and conclusions of Judge Buechler? In terms of the third question, were there any statements or reasons of any of the prior dismissals? I'm assuming what you're asking about, Your Honor, is the township's sua sponte decision to dismiss these 4 dockets. No reasoning was given other than this is just something that they did. This is their public safety director. It was on the township's letterhead. I believe we appended those letters to our papers, but they didn't provide any reasoning for their dismissals other than they did it. And I have no idea why the township, this is your last question. The fourth question doesn't apply to me. The last question is, why didn't the township memorialize any of their prior dismissals? I have no clue. I don't know. We got this out of the blue. But to kind of put my final stamp on the bizarre nature of these proceedings, what's very strange is that from day one, and I have been in this case from day one, no other lawyers. I send no associates to any of these hearings. I've appeared at every single one of the hearings, both before the hearing officer, both before the hearing officer and before Judge Moss. I was at every single one. I was also at the Loudermill hearings. And by the way, the hearing officer is now dead. He died of COVID. He's been gone. He's been dead for a few years. But I have survived all this, as has my client. It's been 11 years, and we believe that it's time that these charges were dismissed. Just give me 1 minute, Your Honor.
Take your time.
I want to address the issue of a stay, which has been addressed by both sides, both before today and in the papers before Your Honor today. There is no stay. The township never sought a stay. In my experience of 30 years, and I think that there are other lawyers that are attached to this matter that have an equal, if not more, number of years as attorneys. I've never seen someone argue a stay when they don't have an order. There is no order. There's no oral order. There's no written order. There's no transcript that provides an order. There never was a stay. So what happened here is there was a decision made by the hearing officer to pursue what I'll call the car charges, which I believe are 2012-221. There was a decision by the hearing officer to pursue those. We did pursue those for several years, and those matters were pursued before Judge Moss, but there was never a stay issued as to the balance of these charges, 26, 27, 27A, 286, and 290A. There just wasn't. So I think what the township has done is they kind of laid in wait here. They wanted to see what happened with Judge Moss. And that one, in those hearings, Ms. Volkert was at every single hearing, along with me, before Judge Moss. But I think, and I don't only think this, I think it's clear from the record, we've cited the relevant sections of correspondence from Ms. Volkert in our papers. What the township did is they waited to see what happened with Judge Moss and with the appellate division. And then they decided, when they didn't get what they wanted, which was to see my client terminated, then they decided to pursue these other charges, which I submit as improper. They never secured a stay. They basically were waiting to see what happened. to determine whether or not they were going to move forward with these charges. So, Your Honor, once again, I told you I was going to be brief, not as brief as I thought I was going to be, but nonetheless, we do rely on our papers, and I have nothing further at this time. Thank you, Judge.
Okay, thank you, Mr. Donahue. And Ms. Volkert?
Yes, Mr. Hazley is going to argue on behalf of
Oh, okay,
Township.
Mr. Hazley.
Thank you, Judge. Just responding to Mr. Donahue's position, Your Honor inquired about equitable estoppel, judicial estoppel. Judge Buckler's opinion went a little further than just brushing aside the case on administrative remedies. He made specific factual findings and legal holdings that we believe this court really has to lay heed to. Just specifically for the record, I'll read what he said. The transcript of the hearing before Administrative Law Judge Moss clearly indicates that the parties agreed that the outstanding charges, these charges, would be hanging out there until it was determined whether plaintiff would remain terminated or be reinstated. Counsel for plaintiff responded that counsel for defendant is almost entirely accurate and did not dispute those charges could be adjudicated following the resolution of the charges that were heard. Plaintiff could have had the outstanding charges heard before the hearing officer and then presumably appealed before Judge Moss. However, whether for strategy purposes or otherwise, agreed with defendant's counsel explicitly or implicitly that the outstanding charges would be stayed. There's the stay. In addition, as noted above, discovery on the outstanding charges commenced in 2013 and is not completed. The administrative process on the outstanding charges commenced years ago. I believe, the latter part is what the court was referring to in the administrative procedure, but its holding as to the parties' agreement to stay the pending charges was pretty clear to the court at that point. And I don't think anything before this forum would change that posture, Your Honor. And, respectfully, that we think the principles of estoppel and res judicata would apply to that.
Is there a reason an order was never entered or requested?
There was an order at what level, Your Honor?
With respect to the stay?
I'm not aware. It was at, it was at the departmental stage. I don't know how common orders are issued at that level,
Okay.
even at the OAL.
Your Honor, if I may interject here, it was absolutely understood every step along the way during that hearing that we were not to touch anything in the record regarding anything with respect to anything regarding the other matters. And the record itself is replete with not addressing anything with respect to any of the other matters. Anytime I attempted to address any of the other disciplinary matters, I was stopped from addressing them. So throughout the entire record, we were not to address it. So whether or not there was an order or not an order, the record itself is replete with that. So there wasn't per se an order of a stay, but the record itself was replete with that.
Okay, thank you. Thank you, counsel.
Sorry for
Okay.
interjecting. I'm having Mr. Hazley address this so as to stay out of it because I am myself sort of a witness in
Got
that.
it. Okay,
So sorry for interjecting, but go ahead, Mr. Hazley.
okay, thank you. And Mr. Donahue, you'll be able to respond, obviously, since it's your motion,
Yeah.
once we hear all the arguments. Mr.
Okay.
Hazley? Okay.
And just further to Judge Buckler's deference to the administrative remedies, he highlighted Mr. Donahue's position at the time that discovery was outstanding on these charges, and he didn't have a sufficient amount of information, I guess, to proceed. So there was an agreement, tacit agreement there that goes into the stay principle. That discovery would proceed after the hearing on the initial charges. And it kind of goes into Mr. Donahue's due process argument in the motion to dismiss that, there's no doubt that he eventually got that discovery, and there's 11,000 pages in the record here. A lot of it we believe is irrelevant, but he got everything he asked for eventually, and he's had his full due process here. So in deference to Judge Buckler's decision, there were factual findings and there were legal findings, and we believe they are binding on this court. And just to remove any doubt, Judge Buckler surmised at the end, equitable estoppel and or judicial estoppel prevent plaintiff from arguing that the outstanding charges were not stayed. I mean, that's a pretty definitive statement. And that encompassed all the arguments that were made, including the statutory arguments regarding civil service deadlines and the 45-day or the 30-day deadline.
Okay, thank you, counsel. Go ahead.
Mr. Donahue also makes a laches argument. We believe, looking at the equities here, balancing them out, both parties appealed the decision. The findings were clear. Both parties agreed to the stay. Chase protracted that discovery process, really that prevented the charges from being heard at the time. The township relied on his representations and his actions, and not challenging. Judge Buckler was clear, if you wanted to disagree with the posture, you should have said so back then. So I think balancing the equities, it doesn't give any credence to his motion at all. As to the reported withdrawal without prejudice of certain docket numbers, if you look at the timing of that, and we addressed this in our papers, but the timing occurred right after the termination of Chase. It was clear to the township that their charges were vindicated. There was no need to process the charges at that time any further. So the police director withdrew certain charges without prejudice. I'm not sure how he determined which ones are to do or which ones to not. But the understanding was always that if appeals were successful, and in part they were, that the charges would be reactivated at a later time, hence the without prejudice dismissal. Your Honor asked about the Camden CWA case. That was and we discussed this in our papers a bit, but my recollection is that was a beat the clock case where an individual, an employee, had retired and a preliminary notice of discipline was issued after his retirement date. Here the charges were issued during Mr. Chase's tenure back in 2012. The fact that they were dormant or certain ones were dismissed without prejudice doesn't change the fact that when the charges were eventually pursued, they were the same charges that were initially issued. They were reactivated, reasserted, whatever you want to call it. So in that regard, it distinguishes the Camden case. And, the dismissal without prejudice links those charges to the older charges. Other than that, Your Honor, I think we can rest on our papers, but if you have any specific questions, I'm happy to address them.
No, I don't. Thank you, counsel. Mr. Donahue.
Yeah, just once again, briefly, Your Honor. So Ms. Volker did chime in for a bit about an issue I want to talk about briefly. So I want to be clear, and I don't think in any way she misrepresented anything, but it wasn't clear to me from the way that she argued that she did not appear at the before hearing officer Shalia Ellington. She was not in the case. She first appeared before Judge Moss. The issue of the stay was not addressed before Judge Moss. I brought it up on the record originally. What are we going to do about all these other charges? And Judge Moss, I actually cite directly from the transcript from that hearing in my papers. Judge Moss said, "It's not before me. The only thing that's before me is this car case." And she identified it by docket number 212, 221, and I don't have the other docket number in front of me. So Ms. Volker was not there at the original hearings before Shalia Ellington. We were precluded from going in to the other docket numbers before Judge Moss because they were not before her. And she made that very clear day one. So I just want to make that point. Your Honor, in terms of the Judge Buechler's decision, we also cited specific language from his opinion. And I'm going to quote it now again for the record. This is on page 2 of our moving brief. Plaintiff can pursue his remedies pursuant to the administrative process. Thus, defendant's motion to dismiss.
Counsel, I'm going to just interrupt you for a second. You can start over. But apparently one of your observers is taping. Mr. Black is taping. Now, if you were in court, you would not be permitted to tape in the courtroom. But according on my screen, it appears that the cue, yeah, I'm looking at my screen next to the name Christopher Black. It appears there's a circle with a red dot. I'm advised that that means that some type of taping device is being used. Joe, this is.
I'm just he just chatted in, Judge. Do you see that?
I asked for permission when I joined. Joe, if I'm going to treat it like a courtroom, which is what you want me to do,
I do.
you don't tape in a courtroom.
He's answered okay, Judge.
All right.